On Close Up this morning, what went wrong for the prosecution in the Michael Jackson trial? Santa Barbara County District Attorney Tom Sneddon and Senior Prosecutor Ron Zonen tried the child molestation case against the King of Pop. Gentlemen, good morning to both of you. Thanks for joining us.
Good morning.
Mr. Sneddon, let me start with you. Before I ask for your personal feelings about the verdict, I know you've probably spoken to the accuser and his family members. How were they impacted by what happened in that court?
Yes, I talked to him immediately after the verdict in the afternoon. He's very down. He's having a difficult time understanding why people wouldn't believe him. He's gone through a lot in his life. He survived cancer, a very serious bout of cancer. He didn't necessarily want to get involved in this case. He disclosed very reluctantly. If you saw the video that we played for the jury, it was very evident that it was very painful for him to tell people what had happened to him. And so it's difficult, as you would expect of any young boy who went on, put his heart and his soul on the line in front of the world, for that matter, and to not be believed. That's a hard thing for somebody to accept at that age. It's hard for any adult, let alone for a child.
Mr. Zonen, a long trial, 14 weeks. I'm sure you've probably second-guessed some things that went on. In the last 36 hours or so, a lot of the jurors have spoken out about the mother, and I know you've heard their comments. And to put it briefly, she didn't have a lot of fans on that jury. Some didn't believe her. Some downright disliked her. Looking back, do you regret putting her on the stand?
Well, there was no question. We had to do that. She had information that nobody else had, and she would have been put on the witness stand by the defense had we not done so. So we really had no alternative but to do that. This is a person who has gone through quite a bit in her lifetime. She was in a very violent relationship for over 16 years with the ex-husband. She had a child who almost died of cancer. And she manifests a lot of the personality traits of people who have gone through that kind of a nightmare, that long-term nightmare.
Let me just interrupt. You say you had to put her on the stand. It seems to me you had to put her on the stand to prove conspiracy, because that's really what she testified about. But if you'd not gone with the conspiracy charge, which a lot of people felt was a reach anyway, then couldn't you have done without the mother's testimony?
No, she would have been called as a witness by the defense. She was already under subpoena by the defense. They anticipated the possibility that we wouldn't call her. That was part of their defense, was that she was the one who fabricated the case and caused her children to conform their testimony to her direction. So they would have called her in any event. But she knew a lot of information. She was there during that period of time. And frankly, a jury would have wondered if we had not called her to the witness stand. So we felt it was appropriate to do.
Mr. Sneddon, do you have any second thoughts about the conspiracy charge? A lot of people felt it made the trial a little longer, a little more complicated, and was, as I just mentioned to Ron, a reach.
Well, we just don't agree with that. Our analysis was that there was substantial evidence to support that charge, and we still believe that. The fact that it extended the trial, I mean, that's the way we have trials for. I mean, I don't agree with that assessment, and we felt that we charged appropriately and still feel we charged appropriately.
You were strongly in favor of a gag order in this case, and what it seemed to mean was that on a daily basis, representatives of the Jackson family who were not under that gag order could go out and speak to the press and rebut what was happening in the courtroom, while members of the prosecution team could not. In hindsight, did that strategy backfire?
No, I don't think so. I don't believe in trying cases in the media. We knew what the downside was to that situation. We knew that they could continue to leak things to the media and to other representatives. But I believe that, knowing the judge as I do, that there would have been a gag order in place no matter what had happened, whether we had asked for it or not, because he had some real concerns about the pretrial publicity. So no, I don't believe that anything different would have happened whether we didn't ask for it or not. There was going to be a protective order.
And Mr. Sneddon, you know that people have said that there was some sort of personal vendetta in this, you against Michael Jackson. You have strongly denied that. But once you started to hear the chatter about it, did you give any thought to removing yourself from the prosecution team in this case?
No, I didn't. There's no reason to, because it isn't true. I'm doing the job, and I have the institutional knowledge of the 93-94 investigation, which, as you know, if you follow the trial, became very important since a number of those witnesses were called. I was familiar with them. They had trust in me. And I did nothing wrong or inappropriate, and I was just doing my job. So no, there was never any thought in my mind to remove myself. And frankly, it wouldn't have done any good, because they still would have said I'm behind the scenes orchestrating this whole thing. So that's just a smokescreen. That's all that is.
Tom Sneddon and Ron Zonen. Gentlemen, as I said, it's easier to come on and do these interviews when you win a case than when you lose it. So thanks for your time this morning.
Thanks for having us.